All right, this is part 2. We are on concepts of law and justice. All right, so how is crime defined? And you're going to see this again on one of the quizzes, so make sure you understand this definition. It is an act or commission of an act or omission of a duty in violation of criminal law, committed without defense or excuse, sanctioned by the state, that makes the offender liable to punishment by the violation of that law. And if you need to pause here to write that down or take a photo of it, you can. So, what is law? Laws are a set of rules that govern the conduct of individuals, and laws are created and enforced by federal, state, and local governments. So, in the United States, we have laws that are set by the federal government, by each state, and by local governments within your city and within your counties. All right, so how do we handle deviance and crime? Well, we have informal social controls and we have formal social controls. So, informal social controls are things within society such as staring, scorning, cold shoulders, kind of peer pressure. And then we have formal social controls such as statutes and written laws. So how do we know how serious a crime is? Well, we have things called mala in se, and you want to know what this means because you're going to see this again. That means something is inherently evil or wrong, such as a felony. That's a classification of a crime that is punishable by a year or more in prison, such as a murder. And then we have things such as mala prohibita, and you want to know what that is. It's to remember that. That means it's wrong because it's prohibited by a criminal statute, such as a misdemeanor. That's another classification of a crime, such as being drunk in public. So our two classifications for crime, such as in Oregon, are misdemeanors. That is punishable by jail of up to a year in jail and a fine, and a felony punishable by a year or more in prison. And there's your there's your felony and there's your misdemeanor or classifications of crimes. And then we also have, every state's different, but in Oregon you have violations. So most of your traffic offenses in Oregon, other than DUIs and some other traffic offenses, are violations. So that means you can't be arrested for them. It's a violation, which means it generally goes against your credit if you don't pay it. Is less than a misdemeanor and it's a fine, or it's a suspension of your driver's license, for example. So make sure you know what those are. So we have felony, misdemeanors, and violations. All right, so reasons for law. Well, the reason we have a law is to prevent conduct that's unjustifiable and inexcusable or inflicts or threatens substantial harm to individuals, to subject to public control persons whose conduct indicates that they are disposed to commit crimes, to safeguard conduct that's without fault or condemnation, to give fair warning of the nature of the conduct, and to differentiate on reasonable grounds between serious and minor offenses. All right, history of law in the United States. So American law is rooted in European, especially English law. So it's basically we get our law from English law or common law. The criminal law that exists obviously comes from English common law, and after the American Revolution, the states adopted many of the criminal laws that had been defined in the common law. And the federal government, however, chose not to incorporate the common law into federal statute. Instead, the United States Congress established its own laws, although they were similar in content to the common law. And we have constitutions, and constitutions are considered the highest sources of law in the country. And constitutions outline the structure of each state government and the federal government. And then we obviously have the United States Constitution, that's the highest source of law. All other laws, including all state laws, state constitutions, and federal laws, must abide by the United States Constitution. And then we have in Oregon, the Oregon Constitution. All other states have their own state constitution, and law emanating from Constitution is called constitutional law. All right. And then these are the amendments that I want you to know. You're going to hear me talk about them a lot. You're going to see them on tests under matching. So make sure you pause here, take a photo of this, or know what each amendment means. So the First Amendment protects freedom of religion, freedom of speech, freedom of the press, and right to assembly. Second Amendment protects the right to bear arms. The Fourth Amendment, which we're going to cover a lot in this class, protects against unreasonable searches and seizures. The Fifth Amendment protects against double jeopardy and self-incrimination, provides due process protection in criminal cases. The Sixth Amendment provides for the right to a speedy trial by an impartial jury. The Eighth Amendment protects against excessive bail and cruel and unusual punishment. And the 14th Amendment extends due process protection to the states. All right, so we're going to stay here for a minute because we're going to talk about the Fourth Amendment. So, because it's really important to understand, and I want to make sure you understand the basics of it. And you are going to see this on the quiz a few times to make sure you understand it. So the Fourth Amendment is, as we learned back here, protects against unreasonable searches and seizures. And it's what we call the search and seizure rule. So the case that's tied to the Fourth Amendment for police officers is Terry versus Ohio, Terry v. Ohio. You're going to need to know that case. And I want you to know about the first thing is called probable cause. So I'm going to speak to you a little bit here, and I want you to remember this. And I try to tell stories to hopefully put it in perspective. So police officers learn about probable cause because probable cause is really important. They have to have probable cause in order to make an arrest or in order to apply for a warrant to a judge in order to enter a house or for an arrest warrant. So, for example, if I were to get a call over the radio that said a bank was just robbed, and the person who just robbed the bank is a white male that's 6'5" tall, has red hair down to his shoulders, is wearing red-rimmed glasses, a white hat, pink shorts, and is running away on 5th Street. And then I start driving there, and I see a white male that's really tall with shoulder-length red hair, wearing pink shorts, red-rimmed glasses, running away from the bank. So I go out and detain the white male, and another officer goes to the bank and gets a witness from the robbery that was the teller that was robbed, and she positively identifies the white male I'm out with. I now have what's called probable cause that any reasonable person would think the person that I went out with robbed the bank. So I make an arrest because I have probable cause. So before Terry v. Ohio, before Terry v. Ohio, that's what I needed to go out with the person and to search that person. So now that person I went out with, I can search that person, what's called search incident to arrest. I can go in their pockets, look for evidence. I can look for the money. I can look for the gun that he used to hold the teller up, all that kind of good stuff. So what happened, though, was one night there was an officer working in Ohio, and it's about, 2 a.m. in the morning, or it's real late, and he sees this officer's just kind of working, and he sees there's a convenience store, and he sees Terry talking to this other guy, and they're looking at this convenience store across the street, and they don't see the cop because they're talking. They're really into talking, and they're watching this convenience store, and they're watching the clerk because it's all glass windows and it's really lit up. And they're talking, and they're watching the clerk, and they're talking, and they're watching the clerk, and the cop's just watching him. He's not really paying much attention. And they go inside the convenience store, and the cop's watching him. and they don't buy anything, and they go to the back of the store and they're watching the clerk, and the cop's wondering, what are they doing? And they still don't buy anything, and they're watching the clerk, and somebody buys something, and they're watching the clerk get into the cash register, and they're really watching them. They still don't buy anything. They leave outside the convenience store. They still don't buy anything. They walk back across the street, and a third person joins them. They talk, all three of them, and they're watching the clerk, and the cop starts thinking. And what do you think the cop's thinking? If you think the cop's thinking that they're casing the place, you're right. That's what the cop's thinking. So they walk back into the place, and they do the same thing. Now, three of them. They watch the clerk from the back of the store. They watch him make a couple transactions. They walk out. They don't buy anything. And so the cop's like, they're getting ready to rob the place. So the cop goes out with them. But the cop doesn't have probable cause, because the cop's just kind of guessing. He's making a really informed guess. He's thinking, I think they're getting ready to rob the place. But he doesn't know for sure. It's not probable cause. It doesn't rise to that level. He can't make an arrest for it because they haven't done it yet. Kind of like the bank robbery. They haven't done it yet. So he goes out with them, and he does what he calls, at that time, he doesn't really know what to call it. He just kind of takes Terry, and he kind of pats down the outside of Terry's front pocket. And he immediately feels the outline of a gun. And he pulls it out, and he's like, Terry. And he runs Terry, and guess what? Terry is a felon. Terry spent some time in prison. And he's like, Terry, you're an ex-felon, and you're not supposed to have a gun, and the gun is stolen. So not only is Terry an ex-felon in possession of a gun, but he's in possession of a stolen gun, which is like too bad. You can't have a stolen gun, not good. And he's an ex-felon in possession of a stolen gun, not good. So he arrests Terry. So Terry actually gets a really good attorney, and the attorney says, this cop did a bad thing. This cop didn't have probable cause to stop Terry, my client, and we're going to get this gun thrown out. We're going to get the charges thrown out. You're going to get off, Terry, because he needed probable cause to go out with you, and he didn't have it. This goes all the way up to the United States Supreme Court, to SCOTUS. That's what I'm going to call it, SCOTUS, because that's what it is called. That's an acronym for the United States Supreme Court, is SCOTUS. It goes all the way up to SCOTUS. And SCOTUS says, wait, we want our cops to be proactive. We don't want our cops just to be reactive, like in that bank robbery I described to you with the 6'5" red-haired man. We don't want our cops just to respond after a robbery, because in that robbery, that man could have killed that bank teller, and sometimes that does happen. People get killed. We want our cops out there being proactive, not just reactive. And in order to do that, we're going to create something called reasonable suspicion. So we already have probable cause, where cops need probable cause to make an arrest, to stop somebody, to get a warrant, and to fully search somebody after an arrest. But right now we're going to create what's called reasonable suspicion. Now, cops can't arrest somebody with reasonable suspicion, and cops can't fully search somebody with reasonable suspicion. But as this Terry versus Ohio situation, if cops think somebody is up to no good, meaning like this Terry v. Ohio, like they're getting ready to commit a crime, they can go out with them and detain them, and they can pat search them. So they can't fully search them, but they can pat search their immediate pockets, their immediate area for weapons. And if they immediately feel like a gun, like with Terry, they can then search them. So that's where the Fourth Amendment is important. So make sure you re-listen to this story I just told, and you understand the difference between reasonable suspicion, which is called RS, and probable cause, which is called PC. And you understand that with reasonable suspicion, an officer can stop and detain somebody. They can't arrest somebody, but they can stop and detain somebody. And that with probable cause, an officer can arrest somebody, stop and detain, and arrest somebody, and fully search somebody. That means go in their pockets. They can't just pat down. Okay, so make sure that you understand that difference. And then I'm going to give you another hint, and that is, depending what state you're in, because it's different per state, I'll tell you in Oregon, an officer can detain a person, do you know for how long? So in Oregon, and you're going to hear this before, an officer can detain somebody for I almost told you wrong, because in Nevada it's different. I'm going to tell you two different things. So in Oregon, an officer can detain a person for a reasonable amount of time. Well, what's a reasonable amount of time? Well, I'll give you a hint. In Nevada, I could detain a person for 60 minutes. So that's around a reasonable amount of time. So it kind of depends where you're at, but that gives you a hint. I used to have students say 24 hours. Well, think about that. 24 hours is not a reasonable amount of time. That's a long time. So it's right around that 60-minute time frame, depending where you are, and you've got to be able to justify it. But in Oregon, if you were to have a quiz question that said, in Oregon, what's the amount of time an officer can detain a person, the answer would be a reasonable amount of time. All right, so you may need to listen to this a couple times to understand the Fourth Amendment, stop and frisk, and the difference between reasonable suspicion and probable cause. All right, so the essential ingredients of criminal law. We have substantial criminal law, and we have procedural criminal law. So substantial criminal law is laws defined as statutory or written law, and procedural criminal law is rules by which a court hears and determines what happens in civil, lawsuit, criminal, or administrative proceedings. So substantial law is the substance. Substantive civil law deals with private actions between individuals, such as wrongful injury, contracts, and domestic relations. Where procedural law provides the structure which such cases should move through the system, provides the rules and regulations for how a case will proceed, dictates roles and responsibilities for each courtroom participant, and can have a significant impact on real issues of criminal justice. Then we have civil cases. So civil law and criminal law are different, and we're going to cover this a few times to make sure you get it. So civil law doesn't deal with someone going to prison where criminal law does. So we just talked about criminal law has classifications of crimes such as misdemeanors and felonies. Civil law only deals with disputes between individuals or private parties or corporation. It generally involves violations or private acts such as contracts or property disputes and family laws. Your plaintiff is the person who initiates the case. Your defendant is the person responding to the case. And it involves the burden of proof is a preponderance of the evidence. So it exceeds 50%, and the punishment is financial. So where a criminal case, the burden of proof is beyond a reasonable doubt, a civil case, the burden of proof is preponderance of the evidence. And where a civil case, the punishment is going to be prison or jail time. Civil case, the punishment is financial. So you're going to want to remember these. These are really important slides. All right, so another case that I'll go over again in the future, but is O.J. Simpson. In the criminal court, the burden of proof was beyond a reasonable doubt. He was looking at prison time. He was found not guilty. In a civil court, the burden of proof was preponderance of evidence, so it was just a little bit more than 50%. He was found guilty, and so therefore the punishment was financial, and so he had to pay money. All right, criminal law, generally understood as having the goal of doing justice, and justice is understood by civilized people as having an independent meaning. Shared understanding in institutions and community that determines what justice is, and we all think justice is different. Things to think about. So what should the criminal law focus on when it assigns punishment? Mental state, intentional or accidental? Was there actual harm done? How do we define harm? Think about this. Did the person just intend to do harm? Is the person dangerous? Was this offense typical behavior or a one-time thing that won't happen again? How do we define dangerous? Are all factors, intent, harm, dangerous, relevant? Are evil intentions a crime? In Los Angeles, 1993, two men, Larry and Emil, were pulled over for a routine stop. Search of the car found several weapons, semi-automatic rifles, pistols, ammunition, smoke bombs, gas masks, wigs, masks, hair color spray, 3 different California automobile license plates, and $1,600 in cash. Prosecutors wanted to charge them with intent to commit a crime and some sort of weapon offense. Their rifles at the time are not illegal in California. Are evil intentions a crime? What do you think? Can they be charged? Should the two be held criminally liable for attempted robbery? If so, what amount of punishment would you impose for attempted robbery? What do you think? I'll ask you again. We'll go back here. What do you think? We're going to come back to this, and I'll tell you when. All right, here's another question. A law-abiding citizen recently discovered to be a former Nazi concentration camp commandant. Does he deserve punishment even though he is no longer a danger, especially if our view on criminals is if they do not pose a threat or danger to society, then we do not need to incarcerate them? Is it justice to punish him after all these years? If so, how do we punish him? What seems appropriate? If not, why? What do you think? If you live next door to a person that was convicted of previously being a sexual predator, what do you think? Is that dangerous? Is that dangerousness? Is it not? All right, so we're going to go to burden of proof. So remember when I told you in a criminal case, the burden of proof is beyond a reasonable doubt? This just kind of gives you a picture of that. That's the highest burden of proof that requires elimination of every reasonable doubt. However, in a civil case, it only goes here. That's the preponderance of the evidence. Greater weight of evidence, accusations are more likely than not to be true. And then we have reasonable suspicion. So that's what an officer needs to stop a person, to do a pat down. And then probable cause is what an officer needs to make an arrest. So this kind of helps you see this is what an officer needs to stop a person, to do a pat down. This one officer needs to make an arrest. This is a civil case to find somebody guilty and hold them liable to give them financial debt. And then this is what needs in a criminal case to find somebody guilty. So remember this is going to be important for quizzes. All right, so where do we get our laws? Well, we have federal criminal laws that are enacted by the legislative branch of the government. All right, we have state criminal laws, laws prohibiting behaviors under the 10th Amendment. We have municipal criminal laws. All right, we have criminal defenses. Defendants are presumed to be innocent until proven guilty. The declaration of someone as not guilty is not the same as finding someone innocent. We have criminal defenses such as the necessity, someone's under duress or entrapment, and you can pause here to read through those more. We have the self-defense, intoxication, and insanity. And we're going to, in the future, be reading through these more, but again, you can pause here to read through these. All right, this ends this video. We'll see you for the future videos.